Good evening, everyone, and welcome to the new law update, SB 940, ADR certification and challenges to California arbitration law. I'm Ala Policastro, CLE advisor with the Beverly Hills Bar Association. Today, I am delighted to introduce our panelists, Anna Sambold and Paul Burns. Anna is internationally recognized as a leading figure in the field of dispute resolution. As a California attorney, mediator, and arbitrator, she has facilitated the resolution of over 1,000 commercial and civil litigation matters with expertise in cases involving multinational and multilingual parties. She handles cases in English and Spanish and is experienced in both common and civil law. Paul Burns is the managing attorney of Burns Legal, a best lawyer, best law firm for 2025. Congratulations, Paul. His career in complex intellectual property and commercial litigation spans over 30 years. Paul is an arbitrator and mediator for the American Arbitration Association with over 20 years of experience there. He is an adjunct professor at Pepperdine Caruso School of Law, where he teaches courses focused on arbitration and advocacy. We can't wait to hear what they have to share with us today. Over to you.
Thank you, Ala. Well, hello, everyone. It's a great pleasure to be here with my colleague, Paul Burns, to provide you an update on the new law, SB 940. Before we start, I just want to remind everyone that we have provided the PowerPoint presentation to the Beverly Hills Bar Association, so you will have a copy of this PowerPoint. We have also provided an official copy of the law, so you can have it, and it's available online anyway, but you can have the copy. We have provided that as CLE, and we're excited to have 200 attendees today. That's pretty exciting. We invite you to submit questions for us anytime during the program. You can submit them using the Q&A function on the bottom, the Zoom toolbar. We will address questions, and hopefully by the end of the program, we will cover everything. We will have time to answer all the questions. But let's dive right in. So SB 940 it was introduced by Senator Tom Umberg on January 17, 2024. Governor Newsom signed it into law on September 29 and 2024. And the most important part, it will be effective on January 1st, 2025. This law substantially affect ADR in California. Why? Well, basically, it adds a new article to the Business and Professions Code. It's called the State Bar Act. It requires the State Bar of California to create a certification program for mediators, arbitrators, and other ADR providers. And also make substantial changes to California arbitration law by adding 2 sections to the Civil Code and amending the sections 1281, 93.3, and repealing section 1283.1 of the Code of the Civil Procedure relating to civil disputes. So, like I mentioned, the law is available online, but we have provided a copy of the official text of the SB 940. And this is kind of our agenda today. We're going to be covering the 8 substantive sections of SB 940. So the first section is about the ADR certification program. Section 2 is about consumer arbitration, the locale of the venue and applicable law. Section number 3 talks about consumer arbitration and small claims. Section 4 talks about arbitrator disclosures and solicitation. Section 5 talks about consumer arbitration solicitation. Section 6, subpoenas. Section 7, depots. And Section 8, discovery. So let's dive right in. let's start with section 1 that talks about ADRs, the ADR certification program. And as I mentioned, the law basically directs the State Bar of California to create a certification program requiring to develop a voluntary certification program for ADR firms, providers, and practitioners. This program shall not require a firm or a provider or a practitioner to be a licensee of the State Bar in order to be certified under the program. So it will be available to lawyers and non-lawyers. So to be eligible to be certified under this program, basically the law provides the following. The firm, the provider, or the neutral must require its arbitrators or its mediators to comply with the ethics standards for neutral arbitrators in contractual arbitration, or require its mediators to comply with the equivalent to the rules of conduct for mediators in court-connected mediation programs for general civil cases. In addition, the firm or the ADR provider or the neutral must have procedures in place for people to make complaints regarding the failure of an arbitrator or mediator to comply with the standards, with its ethical standards, and to remedy that failure. So, what are the specific standards of conduct that and with which arbitrators, mediators, and ADR providers will have to prove compliance, and where this can be found? Well, for mediators, as I mentioned, in the law provides that the equivalent to the rules of conduct for mediators and court-connected mediation programs for general civil cases, and those are provided in the California Rules of Court. And the standards are available online. And here's the link. And they begin at Title 3, Division 8, Chapter 3, Article 2. Basically, these rules of conduct for mediators and court-connected mediation program cases talk about the principles of voluntary participation, self-determination, confidentiality, impartiality, conflicts of interest, disclosure and withdrawal, competence, quality of the mediation process, marketing, compensation and gift, and agreements to disclose. So for in regard to the complaint procedures for mediators, Article 3 of these rules of the California Rules of Court provides a process for all the mediators that are panels and in court panels, and they have a specific procedure defined. So this is what the SB 940 is providing, that the mediator or the ADR provider have some type of complaint process that is similar to this process provided in the California Rules of Court. Some things that you need to keep in mind is that Article 3 include that the complaint proceedings must be private and confidential, and the mediators must agree to disclose mediation communication if there's a complaint about their conduct. People who participate or receive a complaint cannot hear or determine any contested issues related to the dispute and any court action or proceeding. At the same time, SB 940, as I mentioned, requires that in order to be eligible for the certification, ADR providers must require its arbitrators to comply with ethics standards for neutral arbitrators and contractual arbitration. Something that I want to emphasize that is that these ethical standards were adopted by the Judicial Council in July 2002. since that, they have been amended and reorganized and effective since January 1st, 2003. And these ethics standards for neutral arbitrators are available online. And here's the link. And here's a little overview of what these ethics standards provide. Um, the duration of the duty, the general duty to refuse appointment, disclosures, some additional disclosures in consumer arbitrations administered by a provider organization, arbitrators' duty to inform themselves about matters to be disclosed, disqualification, duties to refuse gift, and conduct of proceedings and ex parte communications and confidentiality and compensation and marketing. I invite you to check out those ethics standards that are available online. At the same time, I want to emphasize that these ethics standards for neutral arbitrators are the minimum standards of conduct for neutral arbitrators. And they are intended to guide the conduct of arbitrators and to inform and protect participants in arbitration and to promote public confidence in the arbitration process. And I'm very proud to say that California has been enforcing and arbitrators in California, we have the most stringent disclosures because of these ethics standards for neutral arbitrators. And so the SB 940 in Section 1 provides at the same time some tiers for ADR certification. And these tiers are basically the higher level, or higher tier, are basically awarded to firms or providers or neutrals that demonstrate a higher level of commitment to accountability and consumer protection. And I want to emphasize that these levels of tiers do not reflect an assessment of the quality of the firm or provider or practitioner. These tiers or levels of only reference to standards of conduct. So at the same time, in Section 1, and related to the ADR certification program, SB 940 provides or gives authority to the state bar to deny or revoke certification for any failure to meet or maintain certification standards. The state bar will be charging a fee for to practitioners that are seeking certification. And this fee will be probably higher in the early years of the program while they set up the program and they set up the whole structure. The SB 940 doesn't allow the state bar to use any monies received from the annual license fees collected for purposes of developing the certification program. And lastly, in Section 1, Section 1 defines what is alternative dispute resolution and includes mediation, arbitration, conciliation, and other non-judicial procedures that involve a neutral party in the decision-making process. I have a little concern about that definition because, as you may know, mediators don't have any decision-making power, and it's always and it's one of those my thing that I always hate when people confuse those terms and that terminology, mediation and arbitration. They're totally different concepts. An arbitrator has decision-making power, while the mediator doesn't have any decision power, especially here in California. But some key points that I want to highlight about this ADR certification program is, first of all, the program is non-mandatory, is voluntary for ADR firms, for neutrals, for providers and practitioners. It will apply to lawyers and non-lawyers. I don't know about that. I don't know the state bar has the authority to regulate and certify non-lawyers, but here it is. Also, the certification is not designed to assess the quality of the dispute resolution services. Neutrals do not have to prove how competent or training or how experienced they are in mediation or arbitration to become certified. Because as I mentioned, the levels of tiers only reference standards of conduct. So that can be a little misleading to the public because anyone willing to pay the fees and get certified with no competence, no training, or no experience whatsoever can apply to get certified, and that will be, I believe, very misleading to the public because the public will believe that, oh, this neutral is certified and this one is not, must be because there's something wrong with this one. And so let's go for the one that is certified by the state bar. And they probably believe that is has extensive experience or is more competent than the one is not certified. At the same time, the bill authorizes the state bar to charge fees, and I'm pretty sure they're going to be significant in the beginning while they establish the whole program. And remember, the state bar is not authorized to use licensing fees to fund this program. So I expect those fees to be significant in the beginning. At the same time, it's interesting that the law provides or gives authority to the state bar to deny or revoke certification for any failure to meet or maintain certification standards. That's going to be interesting to see what criteria they're going to use to revoke or deny a certification to somebody, to an ADR provider or to a practitioner. And another point that I'm wondering how that's going to work is about solo practitioners. I'm wondering how they're going to provide credible evidence that they're effectively handling complaints against themselves, because as I mentioned, the certification program requires that the mediators and arbitrators must comply with ethics standards and must provide a process to handle complaints against them. So let's see how that works with solo practitioners. What is next? Well, the state bar is going to create a working group that is going to involve all the key stakeholders, and is going to be finalizing the program probably on launch a program in mid to late 2025. Section the following sections, section 2 to section 8, basically are amendments to California arbitration law, specifically on to consumer arbitration rules. So I will believe it's important to define first the concept before we get into dive deep into what exactly those section 2 to 8 provides. So Paul, could you please define for us consumer arbitration?
Yes, of course, Anna. And hi, everybody. It's really great to be here. Thank you for participating. So one interesting thing about Senate Bill 940 is that it does not have in and of itself a definition of consumer arbitration. So when I was working on this, I thought, where am I going to find the definition of consumer arbitration? It seems to be a very important thing, as you will see, because even though we could spend a whole hour talking about section 1, we've got these other 7 sections to talk about. So where I went was the ethics standards for neutral arbitrators, and the longer title of it is in contractual arbitration. And as Anna was referring to this earlier and showing you the different sections of it, what's interesting is that the ethics standards has the force of law in California. And when we get down to talking about the disclosures that are required in Senate Bill 940, we're going to see a lot of overlap. And because we don't have enough time to go over everything, we'll try to breeze through it a little bit, but we did want to put it in the slides for you so that you could go back and refer to it if you ever needed to. So under standard 2D of the ethics standards, which has been around, as Anna said, since 2003, and it was amended again in 2014 in some parts. Consumer arbitration means an arbitration conducted under a pre-dispute arbitration provision contained in a contract that meets the criteria listed in paragraphs 1 through 3 below. So it's got to be with a consumer party, which we'll talk about in a second. That consumer party term is further defined. Number 2, the contract was drafted by or on behalf of the non-consumer party. So, maybe it's got this adhesion contract element to it. And number 3, the consumer party was required to accept the arbitration provision in the contract. Some of us were participating in a program earlier last week with the principal drafter of this statute, and he made reference to cell phone contracts, for example, where you sign off on that cell phone contract or that account with whatever big cell provider, and you don't really realize it, but there's an arbitration provision in there that you've agreed to. We can go to the next slide and see about the definition of consumer party in the ethics standards. So ethics standard 2E, consumer party is a party to an arbitration agreement who in the context of that arbitration agreement is any of the following. And I'm not going to go through all of this, but you can get the idea. An individual who seeks or acquires, including by lease, any goods or services primarily for personal, family, or household purposes. And then it goes on to talk about other examples as well. But one really interesting component to this is an employee or an applicant for employment in a dispute arising out of or relating to the employee's employment or the applicant's prospective employment that is subject to the arbitration agreement. So if you use the term consumer arbitration, it doesn't usually evoke the idea of an employment arbitration. And on top of everything else, it's not clear from Senate Bill 940 which definition they're going to use, but these are the definitions that are in the ethics standards that have been around for over 20 years. So now we'll continue on with section 2 and back to Anna.
Thank you, Paul. Okay, so let's continue with section 2. So section 2 creates a new section of the Civil Code, and basically this new section specifies 2 new restrictions on consumer arbitration agreements. The first one, on attention, all of you who draft consumer contracts, arbitration clause all over the country. If you're doing business in California, I want you to pay attention to this one, because from now on, starting January 1st, 2025, a seller cannot require a consumer to agree to arbitrate outside of California a claim arising in California, and require the consumer to arbitrate on the claim under the substantive law of the state, of another state different than California. So that section applies to any contract entering to modify or extended on after January 1st, 2025. So if any provision of a contract, of a consumer contract, violates that section, is going to be voidable by the consumer, and the matter shall be adjudicated in California, and California law shall govern the dispute, and the consumer who is enforcing the rights under this section can ask for reasonable attorney's fees and incur in enforcing those rights. And for purposes of this section, adjudication includes litigation and arbitration. So it's interesting in this section that the claimant doesn't have to be domiciled or have to have a residence in California. Any claim arising in California, that's the key, can be, the consumer cannot be required to arbitrate outside of California, under another substantive law that is different from California. So keep that in mind now when you're drafting your consumer contracts and arbitration clauses. And remember, this law is effective and is applied to any contract entering to modify was extended on or after January 1st, 2025. Then we have Section 3. Section 3 provides that basically it provides, as adds another section to the civil code. It basically provides that a consumer must be given the option of taking a qualifying dispute to a small claims court instead of arbitration. If the amount in controversy is less than required by the Small Claims Act. Currently, the Small Claims Act provides that any claim in controversy that is less than $12,500 is eligible for a small claims court. So the consumer now shall have that option to have the dispute adjudicated in the small claims court instead of being an arbitration. So this section applies to a contract at the same time, and just like the Section 2 applies to a contract entering to modify or extended on or after January 1st, 2025. It's interesting that this section doesn't specify who is required to give the consumer the option to proceed in small claims court. So I assume that the obligation will likely fall on the arbitration provider or the neutral, or the arbitrator, depending when the amount of damages at issue is disclosed. It's interesting because I arbitrate a lot of consumer cases, and I remember sometimes having consumers wanted to stay in arbitration, and the business wanted to send them to a small claims court because the amount in controversy. But so it was hard for the arbitrator, for me, to determine what was the amount in dispute, because the claimant keep saying that the amount in dispute was over the $12,500 limit, while the business was saying, well, it is perfect, it's eligible for a small claims court, so please take your case to a small claims court. So, but anyway. So, Paul, what about the following section about disclosures and certification?
Yeah, thank you. I'm going to cover sections 4, 5, and 6. Section 4 is the longest one, and it deals with the requirement of arbitrators making disclosures. And with regard to the disclosures, the language in Senate Bill 940 does not limit it to consumer arbitrations. So I think we have to assume that these disclosures would be required in any type of arbitration. I know that there was a question about whether these provisions apply to international arbitration. There's a separate scheme for that, but again, Senate Bill 940 does not address that issue, doesn't say that it doesn't apply to international arbitrations. But in any event, let's dive into it. And we don't have time to go over every single item, since I violated the rule against packing your PowerPoint slides, but I just wanted to make sure that you went away with a parting gift, and that gift is to have someplace that you could go to reference all of these disclosure rules, at least in summary. So Section 1281.9A, in any arbitration pursuant to an arbitration agreement, and notice again, it's not limited, when a person is to serve as a neutral arbitrator, the proposed neutral arbitrator shall disclose all matters that could cause a person aware of the facts to reasonably entertain a doubt that the proposed neutral arbitrator would be able to be impartial. So the standard there is reasonably entertain a doubt that the proposed neutral arbitrator would be able to be impartial. And so we have these different sections, but the thing of it is, nobody went in and looked at all these sections because there's a lot of overlap. And some of the sections cover the same type of disclosure and require the arbitrator to go back, say, 2 years. Others require the arbitrator to go back 5 years when we're talking about prior conduct. So this particular list on this slide is what's listed in section 170.1 for disqualification of a judge. And we'll focus a little bit more on some of the others like the ethics standards, so we can advance this slide and go to the next one. I want to point out here that one provision in the in section 170.1 for disqualification of a judge is interesting because we don't really see that come out in some of the other areas, and that is bias or prejudice toward a lawyer in the proceeding may be grounds for disqualification. So those of you out there who are arbitrators, keep in mind in terms of your demeanor and keep in mind in terms of sort of your overall conduct in the arbitration that to do everything you possibly can to avoid having any lawyer feel like you are becoming biased or prejudiced against that lawyer. We can go to the next slide. So the next set of rules that have to be disclosed or have to be complied with is any matters required to be disclosed by the ethics standards for neutral arbitrators, which you've been hearing about. Anna brought it up initially. And I just put on this slide the language that introduces the ethics standards as they've been published by the Judicial Council, and to also point out that there's a separate set of amendments that you can get online that show what amendments took place effective July 1, 2014. Next slide. So this is one that we'll go over really quickly. And there's a lot of overlap with what we just saw with the provision that's applicable to disqualification of judges. So number one, you have to disclose whether the arbitrator or family member is a party, the spouse of a party, or officer, director, or trustee of a party. There could be a situation where someone in the arbitrator's family might be serving as a director of some company that comes and appears before the arbitrator, and the arbitrator has no knowledge of that. But nevertheless, it has to be disclosed, and the arbitrator, as we will see, has to do a reasonable investigation. If the arbitrator doesn't know about it, has done a reasonable investigation, it turns out some family member, does have some kind of a relationship here, then the argument that's going to be made by the party that's opposing a vacatur proceeding is that the arbitrator didn't know, and the arbitrator can't disclose what the arbitrator doesn't know. Arbitrator family member has a family relationship with a lawyer in the arbitration. And that also includes whether or not the arbitrator or family member was associated in the practice of law with a lawyer that's appearing in the arbitration within the past 2 years. Number three, arbitrator or a family member of the arbitrator has or has had, with no time limit, by the way, a significant personal relationship with a party or a lawyer for a party. And the definition of significant personal relationship is one where it just merely says includes a close personal friendship. A lawyer for a party means the lawyer hired to represent a party in the arbitration, and any lawyer or law firm currently associated in the practice of law with the lawyer hired to represent a party in the arbitration. That, when you really start thinking about that, it can really make your head explode. especially if lawyers are moving around from firms to firms. Number 4, service as an arbitrator for a party or a lawyer for a party in the arbitration within the past 5 years. And if that is the case, the arbitrator is supposed to disclose the names of the parties, the name of the attorney representing the party in the current arbitration, who's involved in the pending case, who was involved in the prior case, or whose current associate is involved in the pending case or was involved in the prior case. And interestingly, the results of each prior case arbitrated to conclusion, including the date of the arbitration award, identification of the prevailing party, the amount of monetary damages awarded, if any, and the names of the party's attorneys. And so obviously having to disclose this in an existing new case really trumps arbitration confidentiality. And then number 5, compensated service as other dispute resolution neutral, such as a mediator within the prior 2 years. Next slide. I'm not going to go over all of these because of the limited amount of time we have. But I just want to point out, number 15, that there's a catch-all here. Any other matter that might cause a person aware of the facts to reasonably entertain a doubt that the arbitrator would be able to be impartial, bias or prejudice toward a party, lawyer, or a law firm, or otherwise leads the arbitrator to believe that his or her disqualification will further the interests of justice. Everybody's going to ask, how do we know whether or not there might be something that would cause a person aware of the facts to reasonably entertain a doubt? And that's a really good question. Ultimately, a judge or an appellate panel is going to end up deciding that in a scenario where the award of the arbitrator is attacked in a vacatur proceeding. Next slide. Now we're back into the provisions of Senate Bill 940 itself. So recall A1 was all of the disclosures that judges are required to make that could result in a disqualification of a judge. We just went over A2, which are the disclosures that are required in Section 7 of the ethics standards for neutral arbitrators. And now these sections that we're going to go over now are actually in the new statute. And as you can see, there's a lot of overlap. So in 1281.9A3, the names of the parties to all prior or pending non-collective bargaining cases in which the proposed neutral arbitrator served or is serving as a party arbitrator for a party to the arbitration proceeding or for a lawyer for a party. So that would be a scenario where a party has the right to appoint an arbitrator. And then again, you have to make all of these disclosures that I just indicated before regarding the award and the names of the parties and the amount awarded, again, defeats confidentiality. Although this provision here, to try to preserve confidentiality, says it shall be sufficient to give the name of any party who is not a party to the pending arbitration as just claimant or respondent, so not to actually disclose the name of the other parties in the pending or prior arbitration. Subsection A4 talks about the names of the parties to all prior or pending non-collective bargaining cases involving a part of the arbitration or lawyer for a party for which the proposed neutral arbitrator served or is serving as a neutral arbitrator, which is the most common scenario. So in almost all of my cases as an arbitrator, for example, I'm serving as a neutral arbitrator that was selected by the parties or selected as a part of the selection process of the parties. I wasn't appointed by one party, but in drafting this statute, the author thought it was significant to separate these out, and yet the requirements are pretty much identical. In subsection A5, any attorney-client relationship the proposed neutral arbitrator has or had with a party or lawyer for a party to the arbitration proceeding. Another example of a provision, a disclosure provision that doesn't seem to have any time limitation. Subsection A6, any professional or significant personal relationship the proposed neutral arbitrator or their spouse or minor child living in the household has or has had with any party to the arbitration or lawyer for a party. In A7, in a consumer arbitration case, this is where we get into the provision regarding solicitations. And we'll talk about in the next slide what that is. But in a consumer arbitration case, any solicitation made after January 1, 2025, when the statute becomes effective, and within the last 2 years by or at the direction of the private arbitration company to a party or lawyer for a party to the consumer arbitration. And we're going to learn about what those solicitations, what constitutes a solicitation in a moment. And 1281.9b says, subject only to the disclosure requirements of law, the proposed neutral arbitrator shall disclose all matters required to be disclosed pursuant to this section to all parties in writing within 10 calendar days of service of notice of the proposed and go to the next one.
Paul, you were frozen for a little bit.
Oh, okay. I was focusing really on A7. Did everybody get to hear that one?
I think so.
Okay, so yeah, we can go to the next slide. I just want to be mindful of the time and run through the next one really quickly. So for purposes of this section, lawyer for a party includes any lawyer or law firm currently associated in the practice of law with the lawyer hired to represent a party. And prior cases means non-collective bargaining cases in which an arbitration award was rendered within 5 years prior to the date of the proposed nomination. So the look back is 5 years. And let's talk about, in the next minute or two, solicitation. It includes either of the following: private presentations made by a party, made to a party or lawyer for a party by the private arbitration company or the arbitrator; oral or written discussions, meetings, or negotiations to designate the private arbitration company or the arbitrator as the arbitration provider or arbitrator for a party in specific contracts. And then we get subparagraph B, which says what solicitation does not include. Solicitation does not include any advertising directed to the general public, communications indicating a general willingness to serve as an arbitrator or private arbitration company, presentations made by the private arbitration company or the arbitrator at a program or seminar held open to the public. I hope this would be considered to be open to the public. Responding to inquiries regarding the arbitration provider's costs, rules, procedures, or standards. Next slide. And now we have the prohibition in Section 5. During the pendency of the consumer arbitration, a solicitation shall not be made of a party to the arbitration or of a lawyer for a party to the arbitration. So for purposes of this section, lawyer of a party and solicitation is the same meaning we just discussed. This is the absolute prohibition. So if you're an arbitrator that's presiding over consumer arbitrations, you can't make any solicitations, not only to the parties, but to a lawyer for a party, which would also include that law firm that the party's a part of or works for. I'm sorry, that the lawyer works for or is a part of. Next slide. And Section 6, and I'm just going to go over this really quickly because it has to do with the mechanics. Essentially, this is sort of the preview to the fact that now in California, at least with respect to cases that to which California Arbitration Act applies, we now, as arbitrators, have the right to issue subpoenas, or the organization can issue subpoenas, for the attendance of witnesses at depositions for purpose of discovery, and subpoena ducis tecum to bring documents and electronically stored information and other evidence. And so Anna's going to get into the main discovery provision, but this is the provision that talks about the mechanics of subpoenas, which is very much like a situation in certain courts where the subpoena would be issued in blank, and it's going to be filled out by the party serving the subpoena, and it needs to be served and enforced in accordance with Chapter 2, commencing with Section 1985 of Title 3, Part 4 of this code. So let's move on to the discovery provisions. And Anna, back to you.
Thank you, Paul. Okay, so basically sections 6 to 8 are basically expanding the discovery rights in arbitration. And specifically section 7 provides that depositions may be taken on discovery obtained in arbitration proceeding as if the subject matter of the arbitration were pending before a superior court or this state in a civil action. So basically, it's expanding all the discovery rights in arbitration, and is, in my opinion, is basically transforming arbitration into litigation. Now, parties can request and they're going to have all the discovery rights that they have and in a superior court case, in a civil action. And it's basically section 7 is emphasizing that the arbitrator have the power to determine the merits of the arbitration, to enforce the rights, the remedies, the procedures, the duties, liabilities, and obligations of discovery. And at the same time is emphasizing that it has the power to enforce on any discovery request. And interestingly, depots, they need to be taken, they cannot be taken unless leave to do so is first granted by the arbitrator or arbitrators. So that's kind of the only limitation, that depositions for discovery shall not be taken unless leave to do so is first granted by the arbitrator or arbitrators. Section 8 is basically repealing a section of the Code of Civil Procedure. This previous section of the Code of Civil Procedure provides that that in arbitrations of wrongful death or personal injury cases, the parties of all the provisions of the Discovery Act were deemed to be incorporated into every agreement to arbitrate. But now, by repealing that section, that means that full rights under the Discovery Act are then incorporated into every arbitration agreement if the subject matter of the arbitration were pending before a superior court or this state in a civil action other than a limited civil case.
And I know you got more to cover, but I just wanted to make one practice point about the whole idea of now under California law, we have the authority as arbitrators and counsel can request subpoenas to enforce deposition attendance and the production of documents and electronically stored information. And that is that this differs tremendously from the law under the Federal Arbitration Act, because the Federal Arbitration Act, there's Ninth Circuit case law, for example, that expressly states that arbitrators do not have the authority to issue subpoenas to compel third parties who are not signatories to an arbitration agreement to come to a discovery deposition or to produce documents. And so it's really sort of beyond the scope of talking about this statutory provision, but one of the determinations in any arbitration is going to be, does this provision now open the door? Does it apply, or will it be deemed by the federal courts to conflict with their rulings under the Federal Arbitration Act? And the Federal Arbitration Act's applicability is pretty broad, much broader in many cases than maybe an attorney might think. But I don't want to divert too much time on that point. That's a whole nother program that maybe we'll do sometime in the future. So Anna, back to you.
Sure. My recommendation to all of you arbitrators and litigators representing clients in an arbitration is that effective January 1st, 2025, when you have your preliminary hearing with the arbitrator, hopefully you can discuss with your arbitrator all the anticipated discovery issues, all the depots, third-party subpoena procedures, and just memorialize that discussion in an arbitration case management order. At the same time, I believe that these sections 6 to 8, as I mentioned, are just gonna be transforming arbitration into litigation, basically allowing broader discovery rights. Because one of the benefits and one of the advantages of arbitration, it's supposed to be more efficient than litigation, because it's usually less expensive, and quicker than litigation because there's not so much discovery. But these sections 2 to 6 are basically allowing full discovery rights in arbitration, and with the exception that depots, if the parties wanted to take any depots, they will have to ask for leave from the arbitrator. Section 9 provides that all the provisions of the Act are severable. So if any of the provision is held invalid, that doesn't affect other provisions or applications that can be given without the invalid provision. I want to quickly just mention a little bit about the legislative background of SB 940. Well, the law author is Senator Tom Umberg. He's the chair of the Senate's Judiciary Committee. He provided an interview last week, and he confirmed that this law is a reaction to the Tom Girardi scandal. For all of you that don't know, Tom Girardi was a famous personal injury lawyer, and he was accused of stealing all the money from his clients, and it was an article written about the whole incident, and that but I believe unfairly involve mediators and arbitrators, when the neutral that were involved working with Tom Girardi were not serving as mediators and arbitrators. They were serving as special masters or court-appointed neutrals. And I believe that was kind of unfair, because the neutrals, not even special masters, they never have access to an attorney trust account. And it was later find out that the Tom Girardi was basically misusing the funds from his clients when those funds were in his trust account, and no mediator, no arbitrator, no or appointed neutral or special master has any access to an attorney trust account. But we ended up with the certification program and with all these changes to California arbitration. So I don't know. I'm wondering how this is really addressing the issue that they were trying to address, the misuse of funds by the attorney. And the Senator Tom Umberg, he mentioned in regard to the changes to the arbitration law, that his intent was to better even the playing field for consumers, improving consumer awareness and public protection. With that, I think so. Let's take some questions. Let me just stop sharing, and that way we can see the questions. So let's see. Paul, could you see the questions too?
Yes.
Okay, good. So perfect. We have 5 more minutes. So let's see. Under the new 1283.05, it appears that in all arbitrations there is unlimited written discovery. Does that provision replace the rules of jams relating to discovery? So, Paul, I wanna hear what you think, but I believe the law, obviously, all the ADR providers they're gonna have to modify the rules to make them consistent and in compliance with this new law that is effective January 1st, 2025. Oh, what do you think?
Well, there's a landmark decision that dates back to the early 2000s called Armanderas by the California Supreme Court, which dealt with an employment arbitration. But in that case, the Supreme Court of California said that in order for an employment arbitration provision or agreement to be fair, it had to allow for discovery. And so I think the reason why this found its way into this Senate Bill 940 is that the idea was, again, with the focus on consumer arbitrations, which is often, as I indicated earlier, deemed to include employment arbitrations, the idea that the counsel for the employees would be able to do the discovery that's needed to be done. I have a slightly different view of this based on my experience, because most of my arbitrations are large, complex cases, and the lawyers actually insist on discovery. And in cases that I've been on where I'm a member of a panel, but I'm not the chair of the panel, for example, and there's a panel chair who's very, very much against discovery, I really worry that the lawyers get so upset about it that they will, tell their clients, hey, you should never agree to arbitration. So there's certainly a happy medium, but at least the arbitrator's job is to manage the case a little bit more closely than maybe a judge can, and only allow discovery that's reasonable. So the arbitrator will always put some reasonable limits on discovery. But interestingly, this statute, does appear broad and allows for any type of discovery that you can do in court. So I agree with Anna that I don't think that the providers will be able to essentially invalidate that statute by limiting discovery even further.
So they had to be consistent and change the rules to make it consistent in compliance with SB 940, right?
Yeah.
Okay. So next question. I have a certificate of completion in basic mediation training from Los Angeles County Bar Association. I'm currently in full or partial compliance with the new requirements of SB 940, or do I need to recertify under the coursework? Yeah, the certification provided in SB 940 is totally different from any other certification that you may have obtained from other organizations. So, but the good news, as I mentioned, is the certification is voluntary. You don't have to, just if you want to be certified by the state bar. Paul, you want to add something?
Yeah, I mean, the thing of it is that when I first became aware of this Senate Bill 940 and the certification, I was like, oh, what, how many hours are they going to make us take a, training in? And, are we all going to have to take, some new training when we've already had the training? Is there going to be anybody grandfathered in? And the thing of it is now we discover that the certification really doesn't have anything to do with the quality or training of the arbitrator or mediator at all. It has to do with compliance with the applicable ethical and disclosure rules, really. And the complaint process, as Anna explained earlier. So I think it's not a question of recertifying, because there never was a certification requirement like this before. It's a question of whatever our training in the background, or however many years we've been acting as arbitrator or mediator, we're going to have to comply with the certification if we want to be able to say that we're certified. And it has to really do with the procedures and the compliance with the applicable ethical standards that Anna talked about.
I have a question for you. Does any of the grounds for disqualifications of an arbitrator relate directly to allegations to disqualifications of a mediator?
Oh, on this one, no. I mean, the provisions that we talked about are very clear with regard to applying to arbitrators. A mediator's remember not making any kind of a decision. A mediator's facilitating, and Anna gave the link earlier in the slides to the provision to the code applicable to mediators that the certification will require compliance with. There's a little bit of overlap, and for example, in terms of disclosing prior prior relationships, prior conduct with respect to the parties or the lawyers, and you do have to be neutral as a mediator. But I don't believe that the disclosures are as extensive and wide-ranging as they are for arbitrators, and there's no award to invalidate or to get vacated. Now, will someone try to say, hey, there was a biased mediator, so I should be able to undo the settlement agreement? The statute does not address that.
Next question. They may not have access to the accounts, but they can give permission for him to access the accounts. No? I guess they're referring to what I was explaining that happened with Tom Girardi. And as a mediator, as an arbitrator, in my experience, I have never had access to a trust account of one of the lawyers in my cases. So I have a hard time believing that neutral will have access to the attorney's trust account. Paul, what do you think?
I mean, I think the scenario where there is a neutral person that is appointed by a court to oversee a lawyer's access to an account, I mean, that may certainly occur down the road, but that's definitely not anything that an arbitrator or a mediator would typically do as part of those duties.
Are the disclosures you mentioned for arbitrators applied to those who only mediate?
Well, I think under the statute, it's specifically, all those disclosures we're talking about apply to arbitrators. There aren't any disclosures that apply to mediators except through the certification process, where the mediator would have to certify that they're in compliance with the code applicable to mediators, which we really didn't go over in any kind of a detail, didn't have time to.
So under current law, State Bar Rule 2.3, inactive licensees cannot be private arbitrators or mediators. Does the new Business and Professions 6173 abrogate State Bar Rule 2.3? The new Business and Professionals Code creates this certification process for ADR providers and neutrals, and that it applies to lawyers and non-lawyers. So I guess you can think about an inactive licensee as a non-lawyer, then, right, Paul?
That's a really, really interesting question I think an argument could be made for that, but it's not really clear to me how the state bar will view this. An inactive licensee is, still a lawyer, even though they're not licensed to practice law because they're inactive. So maybe that was the original reason for the rule of the state bar. And if the state bar really views that rule as being contradictory or unclear now because of the statute and the certification process for non-lawyers, then maybe the state bar will change that rule. But in the meantime, there's nothing in the statute that abrogates that rule. Expressly, by the way, is what I mean to say, is that the statute doesn't say that it abrogates the rules. So I don't think you can assume that it's been abrogated.
So how about the provision that the mediators serve as a resolution neutral with the prior 2 years? Is this now a disclosure for mediators?
Well, when we were going over it, it was something that was in the ethics standards and in the statute. So it's a disclosure for the arbitrator to make. As a mediator, it would be something that when I act as a mediator, I do disclose whether or not the parties or the attorneys have appeared before me.
And the California Rules of Court provide that as a mediator, you have to disclose any potential conflicts, any potential reasons. I will disclose voluntarily under the California Rules of Court. Let's see. What do you expect will happen when there is conflicting language in the arbitration contracts and in the new bill? Well, let's see what's gonna happen. But that's what I believe is important for everyone to be aware of this new law, and is gonna take effect in a few weeks, January 1st, 2025, and it will be applicable to any contract enter, extended, or modify after that date. So that is going to be interesting to see how everything's going to work. I don't think there was enough time for everyone to get ready. And I can imagine that a lot of people still don't know anything about this. So let's see.
I mean, my comment on that would be that I think unless we're talking about consumer arbitrations where we have a potential adhesion contract, as we discussed, how do you define a consumer arbitration? But if it's a commercial arbitration and there's been actual negotiation over the arbitration provision, and the parties decide, notwithstanding the right to do discovery in Senate Bill 940, assuming that the California Arbitration Act applies, then my opinion is that parties can always decide to agree to a different procedure or to discovery limitations, unless the statute said that, by having some kind of a provision in there, it would invalidate the whole arbitration agreement, or that the provision would be invalid, such as with the venue provision. The venue provision is not something that is waivable, wouldn't you say, Anna?
Yes, I believe so. If the arbitration clause provides that the location of the venue for the arbitration is in another state, and that will be invalid. So, of the applicable law is the law of another state, that will be invalid too.
But the legislature wasn't concerned about commercial parties to an arbitration agreement, agreeing to some other venue outside of California.
Yeah, it seems like the main intent of these changes were consumer arbitration and protect the consumer, or kind of in some way, because consumer arbitration, the consumer just agreed to the arbitration provision by using the service. So we have another interesting question, and I think so you mentioned something about it. To what extent does SB 940 apply to international arbitrations?
It doesn't say whether it does or it doesn't, and there's another. This came up in another presentation that Anna and I did, and I know that one of the it was a presentation that we gave to a group of experienced neutrals, most of whom were arbitrators, and I know that during that presentation, it was pointed out that there are separate provisions applicable to international arbitration that were originally passed to make California a more attractive seat for international arbitration. So the feeling during that presentation was that some of the people that were involved in that were saying that would apply. But in my view, unless Senate Bill 940 specifically excludes some type of arbitration, say international arbitration, my default would be that I would comply with it.
Okay. Another question is, will the state bar provide arbitration certification? Well, the state bar will provide certification to arbitrators, mediators, ADR providers, and so arbitration, yes, it will be included in there. That's the same question. Do international contracts now have to insert California law if one of the parties is based in California?
I think if it's a consumer arbitration, the answer might very well be yes.
Well, as I mentioned, the law is very specific about if the claim arises in California. The claimant doesn't have to have a residence or a domicile in California. So it's not the party's location, if the claim arises in California. It will have to be in consumer arbitration. The arbitration will have to take place in California, and the applicable law will be California law. So next question, is there a contact for volunteering to be part of the state bar committee working on the certification process? You know what? I'm trying to figure that out myself. And I guess the state bar probably has something on the website. I was planning to check on. So let's check the website to see if they have something. Do you have any information about the working group?
The only thing I could suggest is that the organization that exists on behalf of the dispute resolution community that keeps track of all the legislation and that employs a lobbyist to comment on legislation affecting dispute resolution is the California Dispute Resolution Council. I previously served on the board for a number of years before the pandemic came along. And they were very much involved in commenting during the development of Senate Bill 940. And so contacting officers or board members of that organization, the California Dispute Resolution Council, they might be able to answer that.
Mm-hmm. A last question. How do you think this new law affects online terms and conditions?
It seems to me that with respect to, one of the reasons why arbitration has exploded is because of the terms of use of just about every website and application there is, And I serve as an arbitrator in lots of those. And one of the first things I have to try to figure out is this a consumer arbitration? And I just had that come up like a week ago in a preliminary hearing. And it was a situation where you have lots of different situations with terms of use and terms and conditions of online contracts, where sometimes it will say the arbitrations will be under the consumer rules of whatever organization, regardless of whether the person is actually acting in their capacity as a consumer. It could be a business, for example, that, a commercial business that has a dispute with a commercial service provider. So the answer is, I think it will, and certainly if these agreements are applicable to consumers, they're going to have to comply with the provisions that Anna talked about.
So I just want to thank everyone for joining us today. I hope you hopefully you learn all the key aspects of this new law. And if you have any questions, feel free to reach out to Paul or to me. Here's our contact information, our emails, and on LinkedIn. You can find me on LinkedIn too, on a Sambold. And here's our phone numbers. And if you have any questions, feel free to reach out. We'll be happy to answer any questions you may have. And thank you everyone for joining us.
Thank you. It was really a pleasure. Thanks for coming out. Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.